Good afternoon everyone, my name is Karthik and I am legal intern in LEXIS and Company. Today I am going to discuss the Contempt of Court Act. So Contempt of Court means disobedience to court of law or towards its ruling. According to Article 129 of Indian Constitution, Supreme Court has right to punish for its contempt. According to Article 215 of the Indian Constitution, High Court is also known as Court of Record, and it is also having every power of a Court of Record, including the right to punish for its contempt. Contempt of Court Act 1971 deals with the types of contempt of court and also the punishment that is to be given to a person who did such contempt, and also what are the amount that will amount to contempt, and what are the activities which are not amount to contempt. So according to this act, there are two types of contempt: civil contempt and criminal contempt. Civil contempt happen when a declaration given to a court is not being followed, and it will also happen when a court adjudicates something, or court orders a particular person to do something or not do something, and if he violates that order. So these are the two situations when the civil contempt will happen. If someone has given some declaration to court that the thing that he said is true, or on any other declaration that he is willing to follow those things, and after that he is not willing to follow, it will amount to civil contempt. Or it will also happen when any order of a court, after it get passed, and the person who has to do that thing is not willing to do the thing, it will amount to civil contempt. So these are the two things which will amount to civil contempt. So criminal contempt happen if some publication or if any activity that scandalizes the authority of court, or that interferes the judicial proceedings, or that interferes the administration of justice happens. It will happen when that scandalizes the authority of court. That means if someone has said something about the judges, or if someone has did something that scandalizes the authority of court, like they unnecessary criticism, I would say. So that is not allowed. That is amount to criminal contempt. And if there is any sub judice matter, like if there is any matter pending before the court of law, so no person shall have right to discuss about that, because that is pending before the court of law. So until a final order is passed by the court of law, no one has right to talk about it. And also the judgment which is rendered by the court, after it is delivered, we can't say anything about judges, or we can't criticize the court, because only option is to give appeal to higher court. If high court has made any judgment, so at that time, if anyone is not satisfied with the judgment, they can move to Supreme Court. So that is the only solution they are having. So they can't criticize the court and make the people believe that the courts are not, the courts are in such a way or something like that. And administration of justice means, actually judges are also social being. If the thing that is in the discussion of court, or if someone has filed something in the court and that is pending before the court of law, and after that if someone is trying to discuss that matter, so that will also amount to contempt of court. And there are some exceptions. Even though I told that publications about the court that harms the dignity or the authority of court will amount to contempt of court, but innocent publication and distribution of matter will not amount to contempt. Because if someone doesn't know that the matter is a sub judice matter, or that is pending before the court of law, so without knowing that, innocently he published that thing, that won't amount to contempt of court. And also fair and accurate reporting of judicial proceedings won't amount to contempt of court. And fair criticism is allowed. If someone has to make the, someone is criticizing with a bona fide intention, that won't amount to contempt of court. So these are the three exceptions which won't amount to contempt of court. And also the punishment for contempt of court is maximum the person who did a contempt of court will get fine up to 2,000 rupee or 6 months of imprisonment, or he will get the both, either 2,000 rupee or 6 months of 6 months of imprisonment, or 2,000 rupee plus 2,000 rupee and 6 months of imprisonment. So these are the punishment for contempt of court. And it is the discretion of the judges to decide, which are the activities which will amount to contempt of court, and how it influences the judiciary. because if someone made that statement, any serious statement about judiciary, it will amount to contempt of court, and also the punishment will be depend upon the severity or the seriousness of the statement or any publication that he has made. So that is about Contempt of Court Act. Contempt of Court Act, we can say, even though civil contempt is logic, that is reasonable, because if any order passed by the court is not being followed, they has to get punishment, that is okay. But as far as the criminal contempt is concerned, many countries started abrogating that thing. Criminal contempt is something that is against the Article 19, Clause 1, Subclause A of Indian Constitution, right to freedom of speech and expression. The people have right to speak about anything that they want, and also the people have right to express their opinion about anything. And here the judiciary is having that exception. But as far as the judiciary is concerned, there is no need of that exception, because right to freedom is, even though there is right to freedom, that is a fundamental right, that is not applicable to judiciary. So, in my opinion, that is not something we should be there. The countries like America already had that right, but now it is not there. That provision is taken away. So it is the time to rethink whether that provision is needed or not. So that is about contempt of court. Thank you and have a nice day.